afternoon. Welcome to the Legal Tea with LT. This is where I spill about important legal issues in the amount of time it takes me to steep a cup of tea. I'm so excited to be here today. We are finishing up our last week on business. We've talked about business for the entire month of February. And as promised, I have my colleague Zachary Cooper here to help answer your questions on business. I've taken all of your questions. You'll sit in a bunch, but I pared it down to the top 4 most commonly asked questions. So Zach is a business litigator here at the Parvin Group. It is so nice to have you on, Zach.
Well, thanks for having me here, Lindsay. As Lindsay indicated, I'm a business litigator. I'm dealing with disputes within businesses, between businesses, and trying to get the best resolution for our client.
And there is no one better to help me answer these questions than Zach, because he works with you after something problematic has happened. So we've talked all month about how to prepare to set your business up correctly. And so today we're going to answer questions about, okay, what happens when maybe things don't go perfectly. Okay, the first question that I get all the time is, what is a non-compete and should I sign one?
So a non-competition agreement is usually something that's part of an employee agreement. You see them more frequently now. A non-competition agreement is a restriction on the employee to be able to compete with the employer. It's usually speaking to a few things. You're looking at keeping the employee from being able to compete with you within a certain geographical region, within the industry that you work in, and then for a specific period of time. Now, whether you should sign it or not, ultimately that's your own business decision, whether you want to take that job or not, whether it's negotiable or not. But when it comes to the non-competition itself, it has to be part of an otherwise enforceable agreement, which is usually going to be that employee agreement. If you do have questions on the non-competition agreement, if you think it's a little too over-restrictive, then you are encouraged to seek the counsel of an attorney that can be able to look at that specific agreement, see how its terms are speaking to the geographical location, etc., and how that squares with the existing Texas case law to determine whether or not that agreement would be overbroad, potentially wholly unenforceable, or ultimately whittled down to some level at which it would be deemed enforceable.
And with that knowledge, you might be able to go in and negotiate either the non-compete terms or whether or not you sign it with your employer, depending on the field that you're in, for sure. The second question that I get often is, how do I protect my assets if I'm doing business with someone else?
Well, first off, you want to make sure that you have a written agreement that's speaking to the responsibilities of each person, what each person's contributing to any venture that you're entering in with that person. If you're ultimately going to form a business with them, then you can have your operating agreement provide for the contributions that each party made, the value of those, and that'll speak to ultimately, unless the agreement provides otherwise, the ownership interest that each person would have in the company. Otherwise, if you're looking to do something that is between your company and another company, you definitely still want to have a written agreement that would specify who's contributing what, how you're sharing the profits, and how that property will be treated.
The third question that I get all the time, and I'm sure you do too, Coop, is can I sue someone who breached a handshake agreement?
Of course you can sue them. It's whether or not you ultimately be able to recover. You're looking at proof issues. And a handshake agreement is just another term for an oral agreement. That's the term that we use in the law. And what you have there is difficulty in proving the terms of the agreement. And if it's a scenario where the deal worked out, the handshake worked, no harm, no foul. But inevitably, when there will be disputes, you see difficulty in proving the terms. You're looking at perhaps, what was the price to be paid? How long was it supposed to take? The responsibilities of each person. And so absent a written agreement, you really have a tough road ahead of you. And that's
it's
why
more expensive.
Oh yeah, you're spending a lot on the back end on trying to prove those things, or you just cut your losses on the deal.
Right.
That's where, basically putting in the effort on the front end and having your written agreements really pays dividends.
Mm-hmm. And the last question is from me. I want to know, Coop, what is the number one piece of advice you would give a business owner?
Well, I'd say have your paperwork in order. Many times business owners, entrepreneurs are so invested, as they should be, in getting the business off the ground, making sure they have their contacts and marketing in place, that they kind of skip some of the
legal part.
Yeah, and so you're looking at someone that maybe just had a rough and dirty operating agreement that is unclear, it's contradictory, it's just ripe for a dispute down the line. Or if they're doing handshake agreements, like we talked about, with their vendors,
doing business. Yes.
with their vendors or customers, you just want to have your agreements in place to where there's clarity between the business owners themselves, between your business and other businesses that you're working with, and your customers, as well as your employees. I'd really just say have clear, defined agreements in place that you've had someone look at to make sure that they're not contradictory and that they're protecting you as a business owner.
And I think that is the theme, and has been the theme of the entire month of February here on The Legal Tea. Get an attorney to help you form your business, to help you draft all of your documents and make sure your agreements are clear so that you can avoid litigation on the back end. Okay, well, everyone, have a wonderful Thursday, and we will talk soon.